Hi, thank you for using My Court Coach. I'm Jaylyn, and I'm going to be your instructor as we navigate through DV250 Proof of Service by Mail. Now, this form is only used in a domestic violence restraining order matter, and it is also only used by a person that's over the age of 18 and is not a party or a protected party on the request for domestic violence restraining order or the temporary restraining order. This form is typically used for the respondent or the party that is to be restrained, the alleged abuser, to complete their response to the domestic violence restraining order request. It could also be used to mail supplemental declarations, witness statements, attachments, anything that you want the court to view after the initial request for a domestic violence restraining order packet has been personally served on the other party. So if you're the moving party, the person that's requesting the restraining order, and the other party has already been personally served, and you've prepared additional documents for the court's consideration, then you also need to serve the other party, and you can do so by mail by using this form. You could also use this form if you already had your restraining order hearing. So that means your temporary restraining order has been granted. You went to the hearing date that's listed on your notice of court hearing in your restraining order packet, and the other party was there or was not there, but the court went ahead and issued a permanent restraining order, and that could be anywhere from 6 months to 5 years. The court issued that restraining order, the DV130. Then the court can order you, the moving party, to mail that restraining order after hearing. And that's typically if they're not present at the hearing, but if they are, then the court would require you to mail it. Or if the court requires you to mail other things after the hearing, then you could also use this particular form. So let's go through it. Name of person asking for protection should be you or the person that is the moving party. Name of person to be restrained is the other party, the alleged abuser. The server has to be 18 years of age. They can't be listed on the restraining order, or they can't be a protected party, and they have to mail all of the documents. So I, the server, am 18 years of age or over and live in or employed in the county where the mailing took place. So this is important because if the server is in Orange County, for example, and the restrained party, the alleged abuser, lives in Los Angeles County, as another example, then that can affect the time of service. When I say time, I mean like length of service, because typically if you mail something, you have to add an additional 5 days. You have to give yourself an additional 5 days in order for the other party to receive the documents by the deadline, the statutory deadline. And so if they live within the same county, then it's 5 days. If they're outside of that county, then there's other statutory requirements that have to be met. And so if they live in a different state, we know it's 20 days. And I believe if you are outside of the county, then it is, outside of the county where the other person resides, then it is 10 days. So you'd have to mail all the documents checked below to the person in 5. So DV112, the waiver of hearing on denied request for a temporary restraining order. So you can use this form to do that. The response to the request for domestic violence restraining order, an income and expense declaration, a simple financial statement, or the restraining order after hearing, or any other documents that you want to mail. Now, the name of the person served has to be the person that is listed here. And these documents have to be in a sealed envelope, and it has to be at a specific address. So it doesn't have to be their mailing address or the address that's listed on the paperwork. It can be, if you are mailing it to their place of business. That's one place that could be mailed, or just a place that you know that the other party would in fact receive those documents. So it is best practice to use the mailing address that is on the restraining order information, or whatever is filed with the court. So whatever is filed with the court, that is the mailing address that you actually should use. That prevents the other party from objecting and stating, no, like, I didn't actually receive this document in the mail, or they said they mailed it, that's not my address, and they have the court, my address that's listed with the court, and that's where they should have mailed it. And that just provides more delay. So the process server also has to note the date that it was served, and then from what city and state the service was made. And then the person that is completing this form has to be comfortable with providing not only their name, but their address, their city, their state, their zip, and telephone. And it could be a mailing address. It doesn't have to be a residential address, but they have to be able to provide this information in case the other party does object to receiving the documentation, and they want to put that person on the witness stand and question them as to how they actually served the other party with the documents that they said that they actually delivered. If you hire a registered process server, then they're going to include the county of registration number, as well as what county they are registered in. Otherwise, you would just have one of your friends, family members, somebody who's not a party to this case and that's 18 years old, to complete this on your behalf, and they could go ahead and file it directly in the court. You definitely want to make sure that you have a copy, a signed copy, for your own record, so that when you do go to court and the judge asks, then you could go ahead and show this to them in case it doesn't make it into the judge's file. I hope this helps, and best of luck.